Thank you very much, Bjorn. And I'm hoping to keep you awake during the graveyard slot. This is a distinctly non-technical session. I hear from my colleague Mark that you've been steeped in the science of artificial intelligence, so hopefully we're going to take you to a different dimension today. And as Bjorn mentioned, I'm a partner in the law firm of Osborne Clarke, which is an international law firm with offices across the world in the United States, Europe and Asia. And I head up the commercial team at OC, but also the machine learning team. And we're doing increasing amounts of work with AI and machine learning clients, both in the private and the public sector. So it really is a burgeoning area. And as Bjorn mentioned, privacy is an issue that the industry can't afford to ignore. So what are we going to do? What are we going to talk about in our presentation today, or my presentation? I'm going to run through why we should be concerned about AI and big data and try to look at it from a non-technical perspective, try to explain how that technology is different. Then we're going to take a quick look at the European General Data Protection Regulation, which is the new law covering privacy and data protection in Europe. And I think there are three issues within the GDPR that you need to be aware of where artificial intelligence, and particularly machine learning, kind of collides. Then, of course, we need to look at the UK implementation of the GDPR, which is the Data Protection Act 2018. And this is the measure which is intended to keep the UK allied to the GDPR post-Brexit. We'll cover the conclusions, then hopefully we'll have a little bit of time for Q&A. So why should we be concerned about AI and big data? And these headlines perhaps illustrate the concerns that we should have with the technology. And I'll pick on them in no particular order, but the Guardian newspaper refers to some Stanford University researchers, you may have heard about them, who had a scientific study and decided that they could work out whether someone was gay or straight from analysing thousands of selfies of individuals. And a slightly populist headline, but has frightening privacy implications. On a more serious note, what we're seeing, and we're actually seeing with our clients, is the increasing use of facial analytics in the insurance industry. What insurers are actually doing, and there's one startup in particular called Lapita Solutions, which what you do is you mail in a selfie of yourself, and their machine learning solution analyzes your face using thousands of different reference points and works out if you are a heavy smoker, a drinker, and extrapolates using a comparator database of similar faces your life expectancy. And it can actually predict your life expectancy with a huge degree of accuracy. And what's a little bit frightening is that seems to be more accurate than a clinical assessment, a clinical health assessment. Then you've got the Daily Mail's headline, which talks about these voice assistants that are secretly spying on you. So obviously an ongoing privacy concern. The underlying theme being that they're Trojan horses which have been put into your homes at very cheap subsidised cost to enable Apple and Google to improve their NLP databases, which I think probably is what they are. But there's no doubting that they are incredibly convenient as devices. And finally, the issue of bias. So that's a headline that I picked pre the latest news about Amazon. I don't know whether you guys have heard about the Amazon story, but it broke the newspapers last week. Amazon very quietly pulled its AI recruitment assistant because it had discovered that it was developing a bias against recruiting women. And they tried to keep that quiet, but obviously the populist press landed on that. So that's been very quietly pulled. So those are the kind of populist concerns. And the point here is that we're now essentially in an age where the convergence of artificial intelligence, always-on ubiquitous connections, and powerful portable connected devices, the so-called unholy trio, as I've called it, have enabled technology to analyse data very quickly and in real terms, and in vastly more dimensions than a human being ever could. and to combine collective outputs from collective sources in ways that seriously impact the health of our private lives and in ways that would have been inconceivable even a few years ago. We are in an age where we demand instant gratification and answers from our technology, but recoil in horror when we understand the price that we need to pay in terms of data exchange in order to achieve that functionality. And it's in that climate that the new General Data Protection Regulation has actually been passed. But before we get to the topic of the GDPR, we need to understand how data is acquired by technology from a non-technical perspective, from a kind of legal perspective. We tend to assume that when we hand our data over, it's a proactive act. We are thinking about it, it's intentional, and we're handing our data over to a company to process it. In fact, that's only one data acquisition route, and the position is obviously far more complex than this. And the IAF, or the Information Accountability Federation, has identified 3 further types of data acquisition route. First is derived data. Obviously, this is different data drawn from different other sources to provide a new class of data. As that slide shows, it could be, for example, data that Amazon gets on your shopping habits to enable it to offer you or to serve up more similar products. Then there's observed data. That's data that's gathered from surveillance systems or cameras. And finally, the really interesting one, which is inferred data, which is probably the most relevant for this particular talk. This is data drawn from an analysis of existing data to make predictions. And it's this class of data, obviously, which is often referred to as predictive analytics, where machine learning systems are incredibly powerful. So this leads us on to what the real differences are between machine learning and more conventional technologies. Now, I was struggling to find a way to kind of articulate this without going into the technical aspects, because you probably know far more about it at a technical level than I do. I'm a lawyer. I have a jobbing understanding, but what I was trying to do was to provide an analogy in terms of a kind of comparison point, and I came up with this idea. In fact, one of my colleagues came up with this idea, and you might recall this type of picture from the craze in the early 1990s. It's called a magic eye picture. And if you stare at it, by focusing your eyes behind the picture, a 3D image will pop out of that picture. I don't know whether anyone is able to see that 3D picture. You need to cross your eyes, and then an image will pop out of it. No? Sorry? You need to be drunk, actually, to actually... No?
If you're like a meter away, you could look at yourself in the reflection of the glass in front of it, and then you see it.
If you focus behind the picture, so just let your eyes drift out of focus, it should pop out. You've all failed the test. You realise that? No? Has no one got it yet? Okay. All right, well, that's failed, that experiment. But good effort. Yeah. That is the image that would pop out. It's an eagle with its wings outstretched. So I'll take it back and see if you can see it. No? All right, well, I recommend that you buy a book of... Hey, can you see it or not? Yeah? So that was a bit of a gimmick, but what I'm trying to illustrate here is that machine learning is different from traditional technology, as you all very well know, because of the speed, power, and scale of the computing used. It's different because of the extreme pattern recognition capabilities that the technology exhibits. And that's very, very important when you're thinking about how these systems process data. It's different because of its predictive capability. And it's different because it has a tendency to retain the characteristics of the data that it has reviewed or processed as part of its learning or optimization process. That is a very different feature. And all of this leads to the creation of advanced predictive analytics. So what does this mean in terms of real-world examples? Well, what are we seeing as a law firm? And the most, as I illustrated earlier, the most immediate influence is in the way in which predictive analytics are influencing the insurance industry, and not just in relation to facial analytics generally. This is an industry which is absolutely leaping on the technology. And for those of you who don't understand or are not aware of the way the industry works, they work on a concept of pooling. So what they do is they put people into pools and assess their liability for risk within those pools. And what machine learning does is it enables those pools to be narrowed and made smaller and smaller, because the analytics available to the insurers become much, much more precise. So the insurers are able to offer much more targeted products. And if you're within that insurance pool, then you can get a cheaper insurance price. But if you're outside the insurance pool, it becomes much, much harder to obtain the insurance. And that's an ethical question that we don't have time to talk about. But that's what's happening in the industry at the moment. Well, we're talking about the GDPR. You can certainly ask a question, but what I'm trying to do is give you a snapshot. And the other real-world example is in relation to, and it's nascent, but it's in the creation of smart highways and infrastructure. And this is a situation which enables, or technology which enables highways to communicate directly with vehicles and exchange smart data. And there's a concern within the data protection community that this type of data could effectively lead to the state monitoring the activities of individuals, understanding where they go, knowing what their travel habits are. There's obviously a very big privacy impact there. So what the European Union has done is classified that data, that type of smart data, as personal data for the purposes of the General Data Protection Regulation. And of course, the other major feature of concern or concern of the technology is that most complex deep learning neural nets are black box in nature. You all know that if they are really deep networks, whilst you can actually create them and set them to work in any given situation, they are still non-explainable. You cannot explain how or why they reach a particular conclusion in a particular circumstance. And this lack of transparency or explicability is hugely problematic from a legal perspective, and not just from the perspective of data protection, as we're going to see shortly. The general takeaway has to be, how can you justify the use of a system that cannot be explained if it influences the lives, or has the potential to influence the lives of real people? The law is a system that's built on consequence and justice. If you can't explain those decisions, then you're really in a blind alley, and that's a challenge for the industry. It needs to solve that problem. So let's take a look at the General Data Protection Regulation and apply those contextual lessons. And this measure is at the heart of Europe's response to technology. And it replaces the old Data Protection Directive, which previously applied. And what it does is, rather than forcing each individual European country to enact its own data protection measures, it puts in place a harmonised, or what it's attempting to do is put in place a harmonised regime for the management of data and the rules covering trans-border data flows across Europe. And what the public policy measure is behind this is to focus power back in the hands of the data subject, the individual, away from big corporates. There was a perception amongst European legislators that the prior regime was simply giving companies too much latitude in the handling of personal data. So this is a real yank back to the hands of the data subject. Now that measure is absolutely laudable. It's putting power back in the hands of the individual, but unfortunately in doing so it's created some real issues with artificial intelligence, and certainly machine learning or black box type AI. So for those of you that are not aware of GDPR terminology, you have two concepts. It applies to individuals and corporations who process personal data, so-called data processors, and organisations that own or control that data, data controllers. In some cases, those could be the same individuals, but in many cases, they're not, in a kind of outsourced or licensed type arrangement. And under the prior regime, It was the data controllers, the data owners, that were actually liable if anything went wrong with the data. If it was lost, or if it was destroyed, or if it was used contrary to the purposes for which it was being processed. Now, it's the processor and the controller that can be fined. And there's some pretty steep fines. I think the 5% of worldwide turnover is one of the thresholds, which is, if you look at a company like Facebook, is an absolutely astonishing amount of money. So what does it apply to? So we said it applies to PII, or personally identifiable information, and this is typically referred to as personal data. And for the regulations to apply, it must apply to a living human being or an identifiable natural person. And this is one who can be identified directly or indirectly by reference to an identifier, such as a name, an identification number, location data, such as the intelligent transport infrastructure that we talked about earlier, an online identifier, or one or more specific factors relating to their physical, physiological, genetic, mental, economic, cultural, or social identity. So it's an absolutely vast definition. It's any data which touches upon you as a living individual. What we see as a law firm is that, and obviously the GDPR does not, to clarify a common misconception, it doesn't apply to data that is not PII. It only applies to PII. But what we've seen as a law firm is that given the breadth of that definition, it's incredibly difficult to carve away the non-PII data. And actually you get sucked into a situation where you have to comply with the GDPR, even if the data that you handle is incidental, the PII that you handle is incidental. We've got one particular machine learning company that we have as a client that doesn't want to have personal data. It's in the insurance sector. But the underwriters it works with are so incompetent that every time they have a data exchange, they keep sending it PII accidentally. So what this means for my client is that they have to implement a GDPR regime, whether they like it or not. That's just a fact of life. So that's personal data. Principles you need to be aware of, and the first three really are the ones that we need to be focusing on in relation to artificial intelligence. Hopefully you're aware of these. You've got to process the data lawfully and in a transparent manner. It's got to be collected for legitimate, specified purposes. It's got to be adequate, relevant, and limited to what's necessary. It's got to be accurate. You need to keep it for no longer than is necessary, and you've got to keep it secure. Pretty straightforward stuff. So where are the impacts with machine learning and the general data protection regulation? Well, first is establishing a lawful basis for processing. The second is the concept of privacy information notices. And the third is the concept of purpose limitation and data minimization. So let's take each in turn. So Article 22 of the GDPR talks about automated decision-making and profiling. And this is going to be the article in the GDPR which is most relevant to machine learning solutions that are processing personal data. And what it says is that data subjects have the right not to be subject to automated decision-making. That's to say, where there is no meaningful human involvement, or profiling, which is where you're extrapolating personal characteristics of individuals from other data, without their explicit consent. And this applies where the automated decision-making produces legal impacts on the individual. So, for example, where you're applying for a credit evaluation to get a loan or a mortgage, and the machine says, and the computer says no, that's exactly where Article 22 applies. Or whether you're applying for health insurance. If it's incidental, then Article 22 doesn't apply. So what is the problem with this? Well, ever since the GDPR came into effect, most businesses rely on what's known as legitimate interests rather than consent. Broadly speaking, this means a business has to identify a legitimate interest, show the processing is necessary to achieve it and not merely convenient, and they need to balance the rights and freedoms of the individual against the need for the processing. And using legitimate interest is a way to actually avoid getting the direct consent of data subjects. And the reason why businesses are doing this is that consent has effectively been discredited from a corporate perspective. From a data subject's perspective, it's been incredibly strengthened. And this goes back to what I was saying earlier, which is the GDPR is focusing power back in the hands of the data subject and away from corporates. So the real problem with consent under the old regime was that, and we all experienced this, you would be presented with pre-populated checkboxes, or silence would be deemed to be assent. And the European regulators didn't like this, and so they've changed the way consent is actually implemented under the GDPR. They've strengthened the concept. It needs to be clearly and proactively given, and separate consents need to be given for separate processing activities. You can't just imply consent by default. And most importantly of all, consent can be withdrawn at any time. So what this means for the users and implementers of artificial intelligence or black box systems in relation to any application or business case that falls within Article 22 is they need to get the consent of each and every data subject that is contained within that machine learning or the individuals that are all being subject to the processing. And if any one of them pulls their consent, then you can't use the system anymore. Or you can't use the system in relation to them. So you can imagine it's going to be hugely complex to actually manage that process. But great for the data subjects. The next topic is the concept of the privacy information notice. And these are notices that need to be given to data subjects when you're using consent or legitimate interest as a lawful ground for processing under the GDPR. You need to tell them what data is being processed and for what reasons. And Articles 12, 13 and 14 of the GDPR also state that these notices need to be concise, intelligible, easily accessible, and they also mandate, and I'm quoting from the regulation, they need to provide meaningful information about the logic involved. So I wonder if you can see the problem already. This is not just a brief overview, but, sorry, were you going to ask a question? Well, it's got to be sufficiently meaningful to enable the person to understand what is going on. So yes, it's subjective, but it's still got to reach a threshold, hasn't it? So we've already seen that most deep neural networks are black box in nature. Still can't explain how or why they come to a decision in any given circumstance. This is a big problem for the GDPR. How do you provide sufficient threshold, even if it is subjective, in these privacy information notices to explain to the ordinary man in the street what logic is being involved in their machine learning decision when the scientists that have created the solution can't explain it themselves?
How is that any different, though, from the old insurance models? I mean, they were doing actuaries, they were doing risk pooling. You didn't know exactly why you were subject to it. You went into their statistical machine and you came out the other end and that was your policy. There was no meaningful human interaction there.
Well, if there's no meaningful human involvement and it's automated, the same principle applies to that as well. I mean, what I'm doing is it's not something that's peculiar. It's not defined by reference to artificial intelligence. It's called automated decision-making. So if that's a form of automated decision-making without meaningful human involvement, the same principle applies to that. If it's I was talking to Mark earlier about stochastic, random decision-making processes in artificial intelligence. If it's a stochastic process, how on earth are you going to work out how the system got to the conclusion that it did? That's slightly different to an actuarial decision, isn't it?
I don't know. Can we give them a paragraph and talk to them about Monte Carlo and let them...
I don't know if we're doing a discussion now or if
well, I've gone a little bit off piece, but
yeah, no, a lot of people who are working on this now, the lawyers and people working in this area, are saying that, and then like at the Oxford Internet Institute and places like that, are expecting the kind of explanations that I was talking about earlier for the driverless cars are the kinds of explanations that will be sufficient. So they're trying very hard to make sure that you can still use deep learning and things like that. And you're just saying, this was believed because this data set was used for the training and these were the outcomes and this was seen as sufficient because of this testing thing. And it's supposed to be, you're right. Now there's some things that, there's some people who literally can't understand words, right? So you'll never be able to explain to everyone. But there's a lot of this stuff is open until we start seeing the cases come through. So precedent will set a lot of these things, and almost certainly.
And I think you've actually hit the nail on the head. You've anticipated the point that I was going to make. I mean, I think, no, that's all right. I mean, and that's absolutely fine. I mean, I think the issue is really that the perspective of the GDPR is to come at the technology from a white box perspective. So when the GDPR was actually put together by legislators, technology was inherently explainable. It was white box. When you installed it, you knew what you were going to get. There's the answer. You should be able to explain it. Who could have conceived, 10 years ago that we would have had this renaissance in artificial intelligence and people wouldn't understand what the systems were, how they were going to come to a conclusion? Sorry, is there anything you'd like to add to the conversation?
Technologists could have.
Well, I mean, we're still disagreeing about what understand means, but I think we should go on with the conversation.
Yeah, no, that's fine. I'm very happy to be challenged. No, that's absolutely fine. So the point I would make is that Pandora's box has been well and truly opened. We've got this situation now. We've got this hugely effective technology in machine learning, which can be, in some cases, if it's deep networks, can be unexplainable and can be non-transparent. And then you've got this very monolithic approach from the GDPR, which is demanding a white box approach. The Pandora's box has been opened. We're not going to stop using the technology. And I think, to go to your point, we need to have some cases where these issues are actually tested in front of the regulators. And I suspect what's going to happen is that the regulators are going to evolve a slightly different approach to machine learning. But paradoxically, I think what is going to happen is that there's going to be this is precisely the opposite of what the measure was designed to achieve, is going to be a fragmented approach. Because what you'll find is that the German regulator, no disrespect to any Germans in the audience, will take a very literal view of the law, and the English regulator and some of the Irish regulators will take a slightly more pragmatic view. So you'll end up in a situation where different standards apply, which is precisely what the GDPR was not designed to achieve. There are some pragmatic approaches which we're trying to, the industry's trying to resolve in relation to these issues. The first is kind of highly context specific. And it depends on the nature of the system involved and the manner in which personal data is to be collected. It relies upon making relevant information available to the data subject when it's needed, rather than in one huge indigestible lump. And these just-in-time notices rely on statements on information processing being given at the time the relevant question is being asked of an individual. And this can be combined with a layering technique so that the dialogue then pops up or under, which is clickable, and then if you've really got a desire to go do a deep dive into what's going on, you can click progressively through the layers to get to it. And the other thing is slightly more theoretical, and that involves the use of standardized iconography, which is something that the GDPR puts in place. I don't know how this is going to work really, because the concepts contained within the GDPR are so highly conceptualized that putting together a set of consistent icons or traffic light signs to define how data is being processed is going to be a very, very challenging task, and it hasn't yet been done effectively. So the next concern is around purpose limitation and data minimization. And as I said earlier, what these principles explicitly say is that personal data should be collected for specific and legitimate purposes and shouldn't be further processed in a manner which is incompatible with those original purposes. And again, what the regulation, you can see the regulation is doing is it's following a white box model in relation to technology, which is that you should know and understand the point of installation, at the point of installation, what the system is going to do. The real problem with this, of course, is that you don't know that with machine learning systems. As we all know, machine learning systems are great at prediction and uncovering known unknowns, and that's why I put Donald Rumsfeld up, bless him. And in a sense, it's the secret sauce which makes these systems so unique. you may not necessarily know in terms of outputs what you're going to get when you install the machine learning system. And the example that I give in this case is Mount Sinai and Deep Patient, which you may have read about. So what Mount Sinai did was they created a machine learning system, deep learning system, and they gave 70,000 patient records to it. And then they discovered, after the system had analysed it and had learned, that it had become uncommonly good at predicting instances of adult schizophrenia, which is something that the human doctors couldn't do. And they didn't understand how or why it had become so adept at doing it, but it had created a demonstrable benefit for the hospital. And they didn't know at the time they installed the system that they would get that benefit from it. So that illustrates the point. You fast forward, the further illustration is you fast forward to the UK, and you've got the Royal Free Hospital, who sees that and likes it and wants a bit of that, and they implement a similar system, except they go a little bit too far and they give 1.2 million patient records to their machine learning solution. And they're looking at renal failure, advanced renal failure. And the Information Commissioner's Office comes down on them like a ton of bricks and says, you've come very close to being fined. So the question I would put to you, and again it's an ethical question, is Europe on the right side of the fence? Because there is definitely a balance to be had between the rights and and individual liberties of data subjects and the demonstrable benefit of a powerful machine learning solution. Europe is constrained in a way that China and Russia isn't.
So I have a question. I have an interesting thing about China today. That's nice. The question is, and I honestly don't know the answer to this. I'm sort of dancing around the medical stuff, but my understanding was that the error was that they were only going to give it to people, the data for people who have been dead for at least 5 years or something, and they screwed up. And part of the reason people freaked out was because they gave it to Google, who was this evil alien entity.
Yeah.
But would it fall afoul of the GDPR if it was the data of dead people?
No, if it was all dead people, then that's not PII.
Okay.
It has to be a living, natural human being.
Right. Okay.
So yeah, so if it had all been deceased people, then they would have been absolutely fine.
And just really quickly, I was just in China, and they're freaking out because, yes, they have all the data that they can get from their government or whatever, but it's not as good. So it turns out that the data isn't collected as well. So they're jealous. They're trying to figure out
blessings.
why.
Yeah.
Apparently American data is the best, and they're trying to figure out why. They have no idea.
Oh, interesting. Yeah. Well, that's added a gloss to that story. So that's the GDPR. Those are the three issues with the GDPR. And then, of course, we move into the UK Data Protection Act 2018, which is obviously the UK's enactment of GDPR going forward. And what the UK government is intending to do here is to gold plate the UK's data regime so that we get adequacy status when we Brexit. So they've really gone to town on this measure. And I think what they've done is they've actually shot themselves in the foot. I did say this to the chairman of the House of Lords Select Committee on Artificial Intelligence. Didn't get any great sort of reaction from him, but there we go. So what are the particular concerns with this measure? Well, there are two here. The first is data retention, and the second is re-identification of de-identified data. So in its attempt to gold plate the UK's regime, it's created the Data Protection Act 2018 has created two offences. Well, these are just two new offences, but there are others that I'm not highlighting that don't have an impact on artificial intelligence. And effectively what it's saying is that, and I won't kind of read that verbatim, but it's kind of typical UK statutory drafting, which is a little bit of gobbledygook, but what it's effectively saying is that you can't keep it for longer than you need it. And if you do, that's an offence. An offence not only for the company, but an offence for the directors of the company. Unfortunately, they're not imprisonable offences, but the DPA 2018 has an unlimited fines regime. There's no cap on the fines that you can be punished with under that regime. The real problem with this goes back to the way in which machine learning systems function. And as I previously mentioned, in order to optimize their output, an element of the information processing by the machine learning system influences the way in which the system behaves going forwards. In anthropomorphic terms, the skill of the system improves as it processes classes of data. Now, such systems are clearly not retaining the data themselves, but they're retaining what I call so-called information residuals. These are impressions which can influence the weights and biases of the system going forward and improve or optimize its output. So, you know, the classic anthropomorphic analogy is if you're learning a skill, if you're learning a French language skill, you license the books in to learn that skill, and you hand the books back, you're not handing back your ability to speak French, you're just handing back the materials that you looked at. So the key issue with this measure is whether the normal operation of machine learning systems is actually creating an offence which could have consequences for companies and their management. It's not been thought through by the UK legislators. It's one to be tested. And then in section 171, you've got another offence, which is the offence of knowingly or recklessly re-identifying de-identified personal data without the consent of the data controller. And this offence is aimed at pseudonymised data. So this is data that can be reconstituted and obviously not anonymised data, where hopefully that would be impossible. And it's new under the new Data Protection Act. And the real issue with this is the power of machine learning systems to apply predictive analytics to the data that they look at. Remember, the offence is phrased as reckless or intentional re-identification. It's not intentional re-identification. What you don't want to do is end up in a situation where you accidentally derive or infer sufficient information to inadvertently re-identify data subjects. Again, that's an offence under the Act. So the lesson to be learned here is that sufficient safeguards should be put in place to prevent that from happening when you're using machine learning systems. So what were the conclusions to be drawn from everything that we've talked about? Well, I can get that slide to transition. There we go. AI really is different from other technologies. Its black box nature and predictive capabilities set it apart. I do really think that the heart is in the right place with the GDPR. I think the measures are laudable, but you do have to wonder whether we've fallen on the wrong side in Europe of the fence in terms of balancing the rights and freedoms of the individual with the ability of companies to develop and implement machine learning solutions. It assumes that all technologies are white box, and we know that's not necessarily the case with machine learning. And obviously, with the pitfalls that I've illustrated, if you are in the process of implementing a machine learning solution in Europe, there are some pretty big bear traps that you can fall into. So that was my quick run through. I've got the nod from Bjorn, so obviously keeping to the time. If you want to read more about that, then it's in my book.